External sources of interpretation refer to methods or authorities outside of the legal text itself that are used to analyze or understand a particular statute. Let's understand a few of them. Dictionaries. When the meaning of a word in a statute is not defined, the dictionary can be used to ascertain the ordinary meaning of the word. However, it is not necessary that the dictionary meaning will always be relied on by the court, as the words are to be understood in the context used by the statute. In the case of Ramavatar versus Assistant Sales Tax Officer, issue arose that whether betel leaves can be considered as vegetables and be exempt from sales tax under the Central Provinces and Bearer Sales Tax Act 1947. The court examined the dictionary meaning of the word vegetable, which specified that vegetables are comprised or consist of or derived from plants or their parts. The Supreme Court held that while the dictionary meaning is a useful tool, it cannot be solely relied upon to determine the intention of the framers of the sales tax law. The court emphasized that words should be understood in the context in which they are commonly understood. In this case, the court did not consider betel leaves as vegetables for the purpose of sales tax. In the case of Dental Council of India versus Hari Prakash, the court held that a dictionary meaning cannot be adopted if doing so would render the existing words redundant. Textbooks. The use of textbooks and opinions of writers in court interpretations is common. Indian courts often refer to opinions of Kautilya, Manu, and modern authors such as Mulla. However, courts often emphasize that opinions in textbooks may not necessarily align with their decisions. In the case of Kesavananda Bharati versus State of Kerala, the Supreme Court acknowledged diverse opinions in textbooks but chose not to follow them explicitly. Legislative history. Legislative history, which was once considered by courts, now faces mixed views. In A.K. Gopalan versus State of Madras, the Supreme Court stated that parliamentary debates are not admissible for statutory construction. However, in Indira Sani versus Union of India, the court referred to Dr. Ambedkar's Constituent Assembly speech, establishing that debates could be considered for constitutional interpretation. Foreign judgments. Indian courts are not bound by foreign judgments. They only have a persuasive value. After independence, Indian courts shifted from relying solely on English judgments to considering precedents from various jurisdictions, including American judgments. The landmark Puttaswamy judgment affirmed privacy as a fundamental right, drawing comparative insights from laws in UK, US, South Africa, and Canada. Travaux préparatoires. Travaux préparatoires means the materials used when creating a document like a law or treaty. These materials include reports, discussions, and debates. They are kept to understand what the creators meant. International treaties are interpreted using laws from the Vienna Convention on the Law of Treaties of 1969. Article 32 allows using supplementary information like the preparatory work to understand the unclear parts of the treaty. Hope you now understand the different external sources of interpretation of statutes.